So, very good morning, my dear students. You are able to listen, Srinija? The voice audio is clear?
Yes, sir.
Yeah.
Yes, sir. The voice audio is clear, sir.
Thank you. Thank you. So, welcome, my dear students. This will be my last session. You'll have to prepare for the next 10 days rather, instead of 7 days. Of course, the topics are all quite easy, quite smaller also compared to the previous topics which you have. At the fag end of last session, I was talking of class number 49, where we were talking of Arbitration Act. So in class number 49, in arbitration, I spent a lot of time there trying to tell you why we require arbitration. This is one of the alternate dispute resolution mechanism. We had discussed that, it takes lot of time, lot of money going for judicial recourse. So arbitration is one of the alternate dispute resolution mechanism which has found a favor throughout the world. And one of the beauty in the Arbitration Act is, you may be wondering as to, a judge is a qualified person, knowledgeable person, he knows the law, so he can give correct decision. How in arbitration that kind of correct decision could be given? So the main feature all of you must understand is, in arbitration, anyone can become the arbitrator, that is the judge. And correctness of the decision is not at all the criteria. Acceptability of the decision by both the parties is the deciding factor. That becomes the base for arbitration. Beautiful. Now, if you see in villages and all, most of the disputes are all referred to arbitration. What are the disputes you find in villages? This cow has come to graze in his field and he scolded his grandfather. These kind of petty issues. Village panchayat is nothing but arbitration. So when the arbitration starts, both the village panchayat or the arbitrator, the person will ask both the disputing parties, and first question you will put is, do you have confidence in me? Whatever judgment I give, is it acceptable to you? This becomes the base. And once both of them says, yes sir, we'll accept your judgment, arbitration starts. In fact, arbitration, there are a lot of advantages, quite a lot of advantages. You can hold at any place, you can hold at any time, any language, all those advantages. And time is the essence. You can just finish off in 1-2 hearings or even few hearings. Witnesses, lot of freedom is given to you. So the Arbitration Act has undergone, Arbitration Conciliation Act has undergone substantial changes in the year 96. We had the previous Arbitration Act also. Now the purpose of the Arbitration Act is, while giving you freedom at one end, what do's and don'ts is what is discussed in the Arbitration Act. So what you should do, what you should not do. Even though a lot of freedom is given in arbitration, the idea seems to be, as far as possible, the arbitrator must ensure this almost like a judgment given by the court of law. So certain basic issues are addressed in the Arbitration Act. So first we have discussed what are the objectives of arbitration, then the advantages of arbitration, that is quick decisions, minimum technical formalities, flexibility in the procedure, language, all those. Then arbitrator can be technically highly qualified, unlike in case of judge. Then publicity of the press can be avoided in arbitration, because whatever is discussed in arbitration will remain private and confidential, which is known only to the parties involved in the arbitration. And the procedures can be simple, and arbitration awards are enforceable even in foreign countries, like that we had discussed. Then after discussing what is the difference between litigation and arbitration, repeat of the many points. International commercial arbitration, the definition of it also we had discussed. Now, though I have covered all these areas, I thought I should tell one issue. When the arbitration judgment is given by the arbitrator, can it be challenged in a court of law? No, no, and no. This is the striking point which you have to fill in your mind. While the regular court judgments, you're not happy with the judgment, appeal will be allowed automatically. You can go to Sessions Court, thereafter High Court, thereafter Supreme Court. This automatic right of appeal route is available in a judicial process. In arbitration, many of you do not know, once the judgment is given, since you have agreed it should be acceptable to you, you have to accept it. You can't go to a court of law. You can't go to a court of law against the arbitration judgment. Then what is the role of the courts in arbitration? The role of the courts is very limited. They will not go into the facts of the case. In some circumstances, you are not able to appoint the arbitrator. Then the court will appoint the arbitrator. Then if there are some bias on the part of the arbitrator, then court will interfere. Like that, in certain specific cases, only court will interfere. So the main point you must all understand is courts will not interfere in arbitration as a matter of routine. Otherwise, the very purpose will be lost. So one of the very interesting feature, you find this arbitration. Then the whole process of arbitration starts with the agreement. So there should be an arbitration agreement between the parties, even before the contract, even at the time of the contract is entered or thereafter. All those points. We discuss small issues like it should be in writing and there should be clarity of consent. No specific words are required. Somewhere it should be written. In case of dispute, will not go to the court of law. The matter will be settled by arbitration. Those are all very specific requirements. Then ouster of jurisdiction. In other words, there should be a clear understanding in the minds of both the parties that in case of dispute, we are not going to go to the court of law. Ouster of jurisdiction. Then define, and in case of dispute, once the dispute comes only, you can go for arbitration. And the dispute should be arbitrable. There are big list of cases where it cannot be settled through arbitration. Those things you have to keep in mind. And the award is final and binding. So these are the requirements of the arbitration agreement. Then arbitration can be done through reference also. That is, in your agreement, you can refer to another agreement, another terms and condition. Now, one of the terms and conditions provide for arbitration, then that arbitration is also valid. Then we talk about the termination of the arbitration agreement. That is by mutual consent. Suddenly you find the dispute is so enormous, better we go to a court of law. Just as it is, you have voluntarily entered into arbitration, you can even terminate the arbitration. Then once the principal contract is terminated because of novation or discharge, then arbitration agreement also comes to an end. Death of the parties. Death of the parties, it will not affect the arbitration agreement. Please understand, it will be enforced against the legal representatives or by operation of law. Then very important area is certain matters cannot be referred to arbitration. More than what can be referred to arbitration is what cannot be referred to arbitration, matrimonial matters. So anything connected with the relationship between husband and wife or divorce, all those areas cannot go through arbitration. Industrial dispute and taxation matters, labor disputes cannot go for arbitration. Then testamentary matters, that is will related. Will is a testamentary document. It is something which has to be performed by a person after the death of a person. Something which has to be implemented after the death of the person is testamentary document. Those cannot go through arbitration. Then motor vehicle accident compensation. And whatever dispute was then, the Trust Act cannot go for arbitration because the dispute may be between the trustees and third parties. But if some kind of understanding is entered, it is the beneficiary who will suffer. Then how to constitute the arbitrator? We discuss small issues like there can be single arbitrator, you can go for multiple arbitrator also, but it is compulsory you must have odd arbitrators only, 1, 3, 5, 7 like that. Because in case of equality, it becomes a problem. And judgment in arbitration is given through majority only. So you should have only odd number of arbitrators. Procedure for appointment of arbitrators, simple procedure. The parties can decide the procedure. It can be as simple as a toss of a coin, or one person will suggest a list of people where he is apply with them. Then the other person will select from there. Like this process goes on. I have explained all this. And there are no restrictions. Arbitrator can be any nationality. But the thing, they should be capable of contracting. There should not be any bias. Then I spent a lot of time. What is bias in arbitration? See, the one main requirement that the arbitrator should not have any kind of connection with the parties to the contract, financial connection or relationship, or in which can influence his mindset. That is the basic requirement. There should not be any relationship bias, judicial bias, financial bias. So bias, if it is there, the most important point is you must disclose. It's not a disqualification. If you are appointed as arbitrator and you are one of the parties, you have some connection with that, the requirement is you should disclose to the other party. So what is very important is what is disclosure of the relationship. Once the other party feels that is fine, you can always continue as arbitrator. So in 49th class, I had covered up to this much. Then continuing the class in the 50th session also, duties of liabilities of arbitrator. This like similar to a judge. He shall carry on the functions, he shall carry on the duties like a judge. He should be impartial in all times. He should conduct the activities without any delay. He has to maintain confidentialness under every circumstance. Then the deliberation must be there. He should give opportunity to both the parties. He should deliberate the matter very carefully, like that. Then no unilateral communication. Transparency must be there. All the documents you are to give to both the parties. These are all very logical parameters to ensure that there is no, even though it's arbitration, you should not behave in an arbitrary manner. Both the sides has to be heard properly, and opportunity should be given in equal measure. Then the subject goes on, termination, removal, and substitution of the arbitrators. One is, any arbitrator can leave voluntarily. He can resign due to various personal reasons, or he finds the dispute is very complicated, whatever it is, he can always resign and go out. Or sometimes both the parties to dispute may agree that this arbitrator is incapable of giving a fair judgment. So just as they can appoint them, they can also terminate, they can also remove them, okay? Or due to some operation of law, no, he is unable to continue for various reasons, or the court feels he should be removed. These are the circumstances. So once the arbitrator is removed, again the arbitrators, again the parties to dispute themselves will appoint the arbitrator. If for any reason the removed arbitrator cannot be filled up, then the court will interfere. So only for appointment, the domestic arbitration, higher court will interfere, appoint the arbitrator. Then in case of international commercial arbitration, Supreme Court will interfere. This point I have emphasized again and again. Normally, any disputes relating to arbitration, if it is domestic arbitration, it will go to regular district court. If it is commercial, international commercial arbitration, it will go to High Court. Whereas if it is relating to appointment related issue, instead of district court and High Court, it will be High Court and Supreme Court. This point has to be understood clearly. Then what about the conduct of arbitration proceedings? All the procedures and all you decide yourself. The language, the time, the days, the fees, the claims defense. Just like in a court of law, you can have oral evidence, you can have written evidences. Anywhere you can conduct. Under a tree also you can sit down. In a public place also, wherever is convenient to you, can sit down. So a lot of problems which you have in the judicial procedures can be avoided. Then we spent a lot of time on awards. Award is nothing but a judgment. In a court of law, we'll call it as judgment. Whereas in arbitration, the judgment is called an award. We talked of various types of award: final award, interim award, settlement award, additional award. I've explained in detail all these things. Then requirements of these awards, it should be by majority. Not necessarily all the arbitrators must agree. It should be in writing, signed and dated, all this judgment. It should be reasoned, very important. Just like in a court of law, you have to give lot of reasoning. You can't give an award in just one paragraph and say, no, this person is correct, that person is wrong. No, then the court will set it aside. Just like in a court of law, what is the argument of this person? What is the counter argument made by the other person? Why you don't agree with this argument? Why you agree with that argument? It should be a very reasoned way of arguments, counter arguments, and you have to give the final judgment. And the final judgment must not be vague. You have to repay the amount of 1 lakh rupees. This is not a very reasoned judgment. It's very vague. You must tell by what time he should repay, how much, what is the rate of interest, what is the consequence if it doesn't repay. So it should be completely well-reasoned, implementable award. Then time limit for making the award, all that we discussed. There is one fast track procedure also in arbitration. Then what about the correction of award? Those things can also be done within 30 days. If there's some technical mistake and all, those corrections will be allowed. Then enforceability of award. It is not necessary that you have to register in a court of law for enforceability. The moment the arbitration award is given, it is automatically enforceable. Then what about the appeal? You can only appeal on certain grounds. One is, I told you, bias. Second is jurisdiction. Other cases, you can go for review. There is a difference between appeal and review. So review, that generally they will interfere only when the party is under some incapacity or the agreement itself is not valid. Then the procedures were not properly followed. One of the parties were not given proper notice and things like that. Then certain terms were decided in the arbitration agreement, which was not in the terms of reference. The compensation is not as per the agreement. Procedure is not. Subject matter is not capable of arbitration. Just now I told you, certain things cannot go for arbitration like that. Then the award is against the public policy, all those things. Then you can go for review. Now, how do you challenge where you go for court of law? The point which you have to remember again and again is, while appointment-related issues will go to High Court and Supreme Court for domestic and international arbitration, removal, review, those issues will come back to the district court in case of domestic arbitration and the High Court in case of international commercial arbitration. So what the court can do, they have all the options. They can completely set aside the award, or they can confirm the award. They can modify the award at some point, or they can refer back to the arbitrational tribunal and tell them, please make these corrections and all. Then we talk about the cost of arbitration, who has to bear the cost, all that. Then conciliation. So how do the arbitration differ from conciliation? Conciliation here, the parties to the dispute, they talk to each other. The big problem arises because of ego. The dispute between two persons mostly is on account of ego. If they sit across the table and talk to each other, then probably some solution can be found out. So in arbitration, it is imposed judgment by a third person called arbitrator. But in conciliation, the third person only will facilitate talks between the disputing parties, and the disputing parties themselves will come with a solution. That is the idea behind conciliation. Then a lot of sections are there about conciliations, like similar section, how many conciliators, what matter can be referred to conciliation, what cannot be referred to conciliation. Then the judgment in conciliation is called settlement. So in the arbitration itself, we can mix up conciliation, all the role of the conciliator. This is what we have discussed. And finally, the differences between arbitration, conciliation. Then comes mediation. Mediation is more under the Contract Act. It is not covered under the Arbitration and Conciliation Act at all. So this is the chapter where the possibility is about one question around 3 to 4 marks you are likely to get, or even 5 marks in the topic relating to arbitration. So a very interesting chapter, very interesting topic. You'll have to go through very carefully. Then comes the 50th class is Securities Contract Regulation Act. In the Securities Contract Regulation Act, even though stock exchanges, even though the primary market in SEBI, I told you, flourished only in the last 30, 35 years, stock exchanges were there for hundreds of years. In fact, Bombay Stock Exchange is more than 100 years old. So therefore, Securities Contract Regulation Act was there from 1956 itself, along with the Companies Act. Only thing is, in CA, they recently included in the syllabus the Securities Contract Regulation Act. So I started first explaining what is a stock exchange. We are an impression stock exchange is a market where securities are bought and sold. No, stock exchange is a regulatory mechanism, which I've explained. Stock exchange talks of various committees, regulatory mechanism. That is what I have explained. Then today we allow only recognized stock exchanges. Unrecognized stock exchanges are totally prohibited. They are not allowed. So anyone should not participate in unrecognized stock exchanges, all those things. Then how do you grant recognition to stock exchange? See, I told the class also in the very jovial way, the last stock exchange which was recognized was National Stock Exchange, NSE. Recognition was granted about 25 years back. Is recognition done on daily basis? No. But still we get questions in the examination on all these topics. So, Janmantra Papam, that is what I have been jovially telling. You should not leave anything from the examination perspective. So, what are the documents you have to file? What are the rules and regulations? What are the points basis on which the registration will be given by SEBI? Then he talks of withdrawal of registration. So those points also you must go through. Then you read in the Companies Act regarding listing of securities. So then we are taken over for listed companies. Certain additional provisions regarding listing are covered in this Securities Contract Regulation Act. Then if listing is refused, then you go to SEBI, from there SAT, then Supreme Court, all those points we have discussed. Then how to appeal before SEBI, those points I have covered. Then this is what the introductory areas I have covered in this chapter number 50, starting with the Securities Contract Regulation Act. Then in topic number 51, class number 51, continuing the Securities Contract Regulation Act, delisting of securities. See, these are all the questions which are all very frequently given, because now today, initially we had about 20-25 stock exchanges, and most of the companies is to list their securities on all the stock exchange, because listing provides marketability. Investors can easily find the buyer. Now with corporatization and demutualization, I explained this much detail later on. Now, the number of stock exchanges have come down very drastically. Most of the stock exchanges are closed. I've explained for about more than 1 hour why this happened, what is this corporatization and demutualization. So, as a result, today, we have in operation only 2 stock exchanges. One is the Bombay Stock Exchange, the other is the National Stock Exchange. So, what has happened is all the other stock exchanges, the securities are not traded. So we go for delisting. Delisting are of 2 types. Voluntarily, company itself wants to delist, or compulsorily the stock exchange wants to delist it. So how the delisting is done, for what reasons the stock exchange will delist it, all those points we have discussed. So with this preliminary discussion, the Securities Contract Regulation Act, we now went into this act to discuss many issues like what are the objects of the act, to whom the act will not apply, and certain definitions. What is a contract, what is securities, spot delivery contract, options, derivatives. Now, one point I made it clear to the students there are certain definitions which I cannot explain in the corporate law. It takes a lot of time. So, for example, if you have read the SFM, Strategic Financial Management, then it will be easy for you to understand the topics like what is option, what is derivative, what is forward contract, future contract, commodity derivative, ready delivery contract. So certain definitions I did not touch upon because you will be reading more in SFM, those definitions, right? Then contract in certain notified areas become illegal, section 13 and 14. I have explained very much in detail. So they have divided the entire country into 3 areas for regulation purpose. One, areas where stock exchanges are there, recognized stock exchange. Other areas where trading takes place without stock exchange, where SEBI license is required. The third areas, no control mechanism. I explained everything in detail. Then comes members not to act as principal. That is, a broker or a member of a stock exchange, can he do buying and selling for himself? If he wants to do buying and selling for himself, certain extra regulatory precautions are to be taken. All that I've explained. Then one very important topic, title to dividends. If it is a listed company, if it is an unlisted company, if dividend is not paid, you can go to, if the transferee who has sold the shares, but he did not get registration of transfer done within the specified date, obviously the dividend will go to transferor. And the transferee can recover the dividend from the transferor through a court mechanism within the limitation period of 3 years. Now, for listed companies, this has been changed, where if you within 15 days submit certain documents, you can get the dividend from the transferor by the transferee through a stock exchange mechanism. That is what is covered in section 27, 27A and 27B. Then, believe it or not, I spent more than 1 hour trying to explain what is this corporatization and demutualization. From the examination perspective, you'll ask only the definition portion of it. But still, I thought students must know what exactly is this corporatization, demutualization. So the entire background I have explained. Please go through those classes very carefully. What has happened in the stock market today, how this online trading, how these depositories, everything has changed the whole concept and understanding, and how today it is so easy to deal with the stock exchanges. All those points I've explained in the corporatization, demutualization. Then what is the procedure which is adopted by SEBI to give corporatization recognition? Then what are the consequences if you fail to corporatize or demutualize? So in that, continuing the discussion, then I spent a lot of time on what are the powers of central government or SEBI in over the stock exchange, over inquiry into the affairs of stock exchange, powers to make bylaws in the stock exchange, amend the bylaws. These are dry topics, but he gives quite frequently in the examination. Then power of the government or SEBI to make or amend the rules in the stock exchange, power to restrict the voting rights in the stock exchange, power to supersede the governing body, power to suspend the business of the stock exchange, and power to issue directions, all that. Then additional trading floor, how do you establish? I made a remark that today with online trading, this additional trading floor is irrelevant, is not practically existing, but it always exists in the minds of the paper setter. That's the very unfortunate thing. So long as it is there in the syllabus, he is asking all this. So don't leave anything. So SEBI's approval is required for establishing the additional trading floor. Then what is this clearing corporations? So today you don't have physical securities, everything is dematted. So how the, instead of clearing houses of each and every stock exchange, we have Clearing Corporation of India. They have what services they render, and then all those areas we had discussed, and control mechanism of the stock exchange over clearing houses. Then the miscellaneous areas, procedure for adjudication under that, then settlement of administrative civil proceedings, then how to recover the fines, compounding of offenses. Up to here, I have discussed in the Securities Contract Regulation Act. Then the class number 53, topic number 53 is Money Laundering Act, Prevention of Money Laundering Act. As usual, the first 1 hour almost I spent. What is this money laundering? So with the example, I have explained what is this money laundering, why it happens. Main thing is avoiding the taxes. To avoid the taxes, it's not just tax evasion also. It is doing illegal acts and trying to earn money. Be more spiritual or more logical in the explanation why people indulge in all these illegal activities. And more than anything else, I try to emphasize that in what way this money laundering concerns the chartered accountant. And finally, I came to the conclusion, these kind of legislations are meant only for the chartered accountant. How it happens? Because he is the converter. In simple terms, converting this illegal money, black money, or tainted money into white money to show as if it has come from business is called money laundering. So it is only the chartered accountant directly or indirectly who is involved in this. He is the person who certifies the accounts. He does the audit. So this is meant more for the chartered accountant, which I have explained. Then there are a lot of definitions. A lot of questions are given. To understand money laundering, we should first know what is proceeds of crime, what is property, what is scheduled offense payment system, all that. Then the punishment for money laundering. Minimum imprisonment, rigorous imprisonment for 3 years, and maximum 7 years, drug-related offenses 10 years. That's why the importance of this act. Then what is offense which involves cross-border implication? All that I've explained. Now, who are the persons who carry on designated business, profession, and all? So usually the monitoring mechanism in money laundering starts from banks, financial institution, intermediaries. We have defined who are these banks, financial institution, intermediaries. So they have to maintain a lot of details. And whenever the Money Laundering Act, the director asks for details, you have to provide. KYC, know your customer, all these norms have come only through money laundering legislation. Then the obligations of the banker's financial institution, number of times he had given questions in the examination. Then we talked of suspicious transaction report, cash transaction report and all. And finally, the director money laundering, even though he's administrative authority, he has been given quasi-judicial powers. He can arrest a person without arrest warrant. All that the offenses are non-cognizable and non-bailable. Without arrest warrant, you can arrest a person. All that we have discussed. How to impose the fines on the banks and all. Then once the property is attached, after seizing the property, how the attachment order will be given. Of late, all these small questions are given in the examination. I've covered all that. And 1 or 2 small amendments are also there, which I've put already in the material, those areas. Go through that. Procedure for adjudication. So how they seize the assets, how they attach all this. And you're not happy with the order of the adjudicating authority, go to the appellate tribunal. And the appellate tribunal constituted under Money Laundering Act is similar to that of the appellate tribunal which you got in the Foreign Exchange Management Act. Then all the decisions will be given by majority. These are all very, very trickish technical administrative issues. And this is what he is giving the examination. So he is expecting the chartered accountant to read completely. I have been telling you this again and again. The moment you mark in your mind, there is nothing important or unimportant in a professional examination, then you will be able to answer this well. This is the secret of success. Then constitution of special court, offenses to be cognizable, non-bailable, who are all the authorities under the act, powers of the investigating agencies, recovery of fines. This is all I have covered in this topic, money laundering. Then in class 54, I talked of securitization, reconstruction of financial asset, enforcement of security interest. We popularly call it Securitization Act or SARFAESI Act. I have gone through the SARFAESI Act, many books and all. Nowhere he has given the introduction. Why do you want the SARFAESI Act? So I spent a lot of time in my class. I've given the introduction for about 1 hour along with the drawing. What is the great idea? I told in a very jovial way, this under the Securitization Act, we have created a new company called asset reconstruction companies. And these asset reconstruction companies are nothing but gundas. I have explained in a very jovial way. So they try to recover the money from the companies. They play alternate mechanism for banks and financial institutions. They are given huge powers under the Act, and I've explained all that, the background. So I cannot explain it now in 5 minutes and all. Go through my classes very carefully. In the Securitization Act, you find quite a lot of definitions. After you cover the definition, how to constitute a segunda, that is the securitization company, incorporation registration, and you are to register with RBI. What is the procedure for registration? And when after registration also, RBI has got powers to cancel the registration, how they cancel the registration, all that. Then after, I've explained what is the list of financial assets which can be used for securitization. What is the meaning of securitization? Then unless you know the topic, I may not be able to explain here. So then the parts of the securitization process, I've explained all this. Acquisition of financial asset, funding of securitization. Then the second portion of securitization is asset reconstruction, the helping hand which the banks and financial institutions could not give, but the securitization asset reconstruction company can give. So what is that asset reconstruction? All that I've explained. Then comes the powers of the Reserve Bank of India over these special purpose vehicles, namely the asset reconstruction companies. The power to call information, power to call for audit, inspection. How do you enforce the security interest? When the asset reconstruction mechanism fails, then the securitization company, that is, sorry, the special purpose vehicle, the asset reconstruction company, how they sell the assets and retrieve the money, the whole mechanism I have given. Now, when the Securitization Act will override many other acts, therefore, once the asset reconstruction is over, once the special purpose vehicles come into picture, what about the provisions of the Companies Act? Can I appoint the directors? Can I remove the directors? All those points I have explained very much in detail. Please go through. And these directors who are removed will not get any compensation for loss of office. So you're not happy with the judgment, when you can go to DRT, DRT, Revenue Tribunal, then thereafter Appellate Tribunal. Then you have a special registrar of companies like that, registrar of securitization, offenses, penalties, all that is covered. Then the miscellaneous provisions, then who are all the exempted transactions under Securitization Act and the Limitation Act, their applicability. Until here, I have covered in this Securitization Act. Please understand, whatever is in your syllabus, only you read to that extent. Because there's one more in the elective paper, you go very detailed into the Securitization Act. Here only basic provisions, whatever I given the material that forms your syllabus, please go through only that much. Then comes the next topic, next 4 classes, I have explained in detail IBC, Insolvency Bankruptcy Code of 2016. Now, questions up to 10 marks out of 100 is being given in this IBC, Insolvency Bankruptcy Code. This is the reason very elaborately I've explained in detail what is this IBC and all. One of the wonderful piece of legislation which the BJP government has created. Hats off to them. But before I proceed further, one point. Now, because of the COVID which has come in the last 6 months plus, there are certain notifications which have come under IBC. For example, certain sections have been said for 1 year it won't apply. Certain limits have been raised from 1 lakh to 1 crore. Certain dates, certain time limits have been elaborated. Please don't bother about it. I am repeating that. Those are all temporary measures done by the government. So all those notifications, even though he has given in the RTP, you don't have to bother. I repeat, you don't have to bother. Whatever dates, whatever limits, whatever figures I have given in my material, please read that only. I repeat again, because of the COVID situation as a temporary measures, certain sections have been suspended, certain sections, the figures have been changed, certain sections, very elaborate relaxations have been given. Those are all for temporary periods. This you don't have to bother from the examination perspective. 1,000 times I'm telling. So you write the figures which I have given in the material, or even write the latest amended figures, both are one and the same, you'll get the full marks. This is one thing. And second thing is, you are aware, just a few days back, the Companies Amendment Act of 2020 has been passed by Parliament. Anyhow, that will not apply to those writing in November exam. It will apply to those writing in the May 2020 or November 2020. I've gone through the entire amendments. The amendments are only pertaining to some decriminalization. Penalties have been changed. Certain fines, imprisonments have been converted into penalties, and not much change at the final level. So don't bother much about it. Another major area what they have done, they have reintroduced the producer companies which were there in the 1956 Act. They have brought it back to the 2013 Act. But anyway, as per the institute notification, producer companies are not in your syllabus. I repeat, producer companies, 1956 Act also is not in your syllabus. It was there earlier, but 1 year back, the institute has notified and removed the producer company in your syllabus. Therefore, the producer company amendment will not apply to you unless they change the syllabus and reduce the producer company. Until now, the institute has not done. So technically, the amendments, 2020 amendments, is practically redundant. Anyway, for those who are writing the May examination and November examination, if at all there are any changes and all, because I had to wait for May, I had to wait up to December. Similarly, for next November, I had to wait up to May 2020. I will prepare a video, a capsule of all the changes, and those changes you can go through. So don't have to bother. You please read. I have been talking to Shetty sir also. He was telling, sir, one problem with the students is they're not prepared much. That is very unfortunate. You have to prepare. I know you are going for audit. You don't have much time. Still, you have to sit and prepare. Then only it will serve the purpose. So to start with, in IBC, what I did is, I spent a lot of time trying to explain who is this chartered accountant, cost accountant, and company secretary who has to write an examination, and once he qualifies, he will be called insolvency professional. And this insolvency professional will be appointed as resolution professional, and he will be sitting in the seat of the managing director and managing the companies for some time until the creditors are paid. So I've explained all this. Why this IBC? One of the most important features is it's a consolidation of the many acts, almost 14, 15 legislations, state-wise, central-wise, different legislations have been scrapped, and the insolvency has been brought under one heading, IBC. And I explained then the regulatory mechanism of the IBC. Who is this insolvency professional? Who are these insolvency professional agencies? The CA Institute, ISW and CS Institute has started separate legal entities. They are called insolvency professional agencies. They have been given certain powers. So all that I have explained. Then information utilities, a new concept, data banks which are established. Then you have got the regulatory authority, quasi-judicial authority, namely for corporates, it will be controlled by company law tribunal, and for non-corporates, it will be controlled by DRT, Debt Recovery Tribunal. Then you also have a board, just like SEBI, Insolvency Bankruptcy Board of India. So there's a very detailed chapter. I spent almost 4 classes explaining all this. Then comes certain definitions under IBC. Then we spent a lot of time. Who is that insolvency professional? What about the registration? All that. Then this introductory part, after it is over, we started with corporate insolvency resolution process. How the triggering mechanism will start. So the default will be, we explained who is a financial creditor, who is an operational creditor, then the company itself, the corporate debtor. The triggering will be started if the payment is not made to the creditors 1 lakh rupees or more. I repeat, this figure has been changed to 1 crore. In the examination for November, at least, if you write 1 lakh also, you'll get full marks. If you write 1 crore also, you'll get full marks. So you write only 1 lakh, which I've given in the material. This is how the triggering will start. So it's all very time-bound process. Now it's not just waiting for years together. Within 180 days, within 360 days, within 45 days, within 90 days, time-bound, the tribunal has to give judgments and all. So I've explained in detail how the application will be made by the financial creditor, then application by the operational creditor, then application by the company itself, the corporate debtor. Then along with the case laws, one of the important feature is in IBC, even though they said while releasing the syllabus, overview of the insolvency bankruptcy code, from the 3rd examination session onwards, they started giving a lot of case laws in the examination. So in fact, I've covered all the case laws, go through all that very, very carefully, first page to last page. Then withdrawal of application. Now a lot of changes. These are all the latest issues. Yes, you can withdraw the application also. Then you cannot make further application. Then what is the time limit within which the insolvency resolution process? So initially, to enable them to company to pay credit to the payment to the creditors and all, the corporate insolvency resolution process will be undertaken. Then in class number 57, continuing the discussion, public announcement. Once the resolution professional takes over, the public announcement has to be made in the newspapers. He had given all these questions in the examination. Then comes the moratorium order. What should not happen in this 6 months? Except for routine things, nothing should happen. Then what is the role of the interim insolvency resolution professional? He will take over the management, what he can do, what are the powers, what are the limitations. Then about the constitution of committee of creditors. There are a lot of amendments which have taken place. All the amendments I've included, and you must go through only those you have to write in the examination, those amendments. Right. Then how the meetings of the creditors, committee of creditors will be held. Then after that, the interim resolution professional will be appointed as a regular resolution professional. And once he is appointed, he will prepare the information memorandum and finally come out with the resolution plan. Then once the resolution plan is ready, how it will be approved by the committee of creditors, all those points we have discussed very much in detail. Then thereafter, liability of the corporate debtor, section 32A, new chapter has been added. I repeat, section 32A, liability of the corporate debtor, 1-2 issues. And once the corporate insolvency resolution process fails, the only alternative is go for liquidation. Now, please listen very carefully. In the compulsory winding up is done under the Companies Act. Compulsory winding up. Voluntary winding up has all been shifted to IBC. And that is what we are discussing. One is for solvent company, different procedure. Insolvent company, different procedure. So all the winding up procedures have been brought here. So in case of solvent company, which they want to go for liquidation, or this who have no insolvency, they also liquidation process will start. What are the effects of the liquidation order? One point students must know, same provisions which are in the Companies Act is repeated. So a lot of changes are there here and there. So must, for example, preferential creditors that paying the amount, all that List has been changed in the IBC. You have to go in that. Powers and functions of the liquidator, ascertain the claim. Then that's called liquidation estate. What are all the assets of the company? Then the preferential transaction, preferential creditors, we saw in the Companies Act winding up is different from IBC preferential creditors. Then the position of secured creditors is totally different. I repeat 1,000 times, the priority in the payment or distribution of assets under the Companies Act for compulsory winding up is different from the winding up which takes place under IBC. The procedure, the rules, regulations are quite absolutely different. Then you have the fast track insolvency resolution process. This is IBC related winding up when insolvency is there. Second is voluntary winding up when solvency is there. How do you do that voluntary winding up? That he has asked in the examination. And thereafter, what I've done is I've discussed in class number 58, the last class, lot of case laws on the subject. Almost 21 cases. Most of them are Supreme Court cases and some of them appellate tribunal cases. Go through this. Each and every case is a different issue. Any of these you can give the examination. So this much you must go through from the examination perspective. So my best wishes to all the students who are writing now in the November examination. That's all. The time is just short. Just 1 month plus is available. Use this class for revision purposes. Wish you all the best. Now for those writing in May 20 or November 20 examination, go through these video classes very much. There are not many changes. Of course, I have to wait till another 2 months. I don't find many changes coming up because Companies Act also, as I told you, only some small changes have been made. I will come out with a separate video class. Don't bother about it. I will come out with a separate video for changes for those who are writing the May 20 examination as well as the November 20 examination. And wish you all the succession of success. One small request to the students. Now, Mr. Shetty in caps have been doing a wonderful job. He has really gone on board in trying his best to do service for the student. So as a Guru Dakshana for us, you have to put in a word to your other friends and all, so that please join caps in large numbers. So wish you all the success. So I request Srinija, any questions are there, I'll be able to answer before I wind up. Srinija, any questions?
As of now, I've not got any questions, sir. If
Okay.
they're having, they can ask it here.
Right.
Yes, sir.
Once again, I repeat, my cell number also I've given. Those who don't have can note it down. 9490190956. This is my cell number. I repeat again, 9490190956. So give me a WhatsApp message or message. Don't call me. I'll be in various classes. I will not reply over phone. You send me SMS or you send me email. I'll be able to answer all your queries. Email, that is ljayaraman@rediffmail.com. So any of the other problems which you have, you can always contact CAPS. Wish you all the success. God bless you all. Thank you. Thank you very much. Thank you.
Thank you so much, sir.
Thank you,
All the best.
sir.
Thank you, sir.
Bye.